Okay, Weisgram versus Marley Co. is a Ginsburg opinion from 2000. This case concerns the respective authority of federal trial and appellate courts to decide whether, as a matter of law, judgments should be entered in favor of a verdict loser. The pattern we confront is this: plaintiff in a product liability action gains a jury verdict. Defendant urges unsuccessfully before the federal district court, but successfully on appeal, that expert testimony plaintiff introduced was unreliable and therefore inadmissible under the analysis required by Dubert and Merrill Dow Pharmaceuticals, Inc., shorn of the erroneously admitted expert testimony, the record evidence is insufficient to justify a plaintiff's verdict. May the Court of Appeals then instruct the entry judgment as a matter of law for defendant, or must that tribunal remand the case, leaving to the district court's discretion the choice between final judgment for defendant or a new trial of plaintiff's case. Our decision is guided by Federal Rule of Civil Procedure 50, which governs the entry of judgment as a matter of law, and the and by the court's path-marking opinion in Neely v. Martin, 1967. As Neely teaches, courts of appeals should be constantly alert to the trial judge's firsthand knowledge of witnesses' testimony and issues. In other words, appellate courts should give due consideration to the first instance they're looking to follow. But the Court of Appeals has authority, in per stare decisis. You should follow it unless they have a good reason not to. But the Court of Appeals has authority to render the final decision. If, in the particular case, the appellate tribunal determines that the district court is better positioned to decide whether a new trial rather than a judgment for defendant should be ordered, the Court of Appeals should return the case to the trial court for such an assessment. But if, as in the instant case, the Court of Appeals concludes that further proceedings are unwarranted because the loser on appeal has had a full and fair opportunity to present the case, including arguments for a new trial, the appellate court may appropriately instruct the district court to enter judgment against the jury verdict winner. Appellate authority to make this determination is no less when the evidence is rendered insufficient by the removal of erroneously admitted testimony than it is when the evidence without any deletion is insufficient. So I think ultimately that paragraph is the holding that we're going to reach by reading the rest of this case. Part 1, setting forth the facts. Firefighters arrived at the home of Bonnie Weisgram on December 30th of 1993 to discover flames around the front entrance. Upon entering the home, they found Weisgram in an upstairs bathroom dead of carbon monoxide poisoning. Her son, petitioner Chad Weisgram, individually and on behalf of Bonnie's Weisgram's heirs, brought a diversity action in the United States District Court for the District of North Dakota seeking wrongful death damages. He alleged that the defect in an electric baseboard heater manufactured by defendant Marley Company and located inside the door to Bonnie Weisgram's home caused both the fire and his mother's death. At trial, this is kind of the cause of action. At trial, Weisgram introduced the testimony of 3 witnesses proffered as experts in an endeavor to prove the alleged defect in the heater and its causal connection to the fire. The district court overruled defendant Marley's objections lodged both before and during the trial that his testimony was unreliable and therefore inadmissible under Federal Rule of Evidence 702 as elucidated by Dubert. At the close of Weisgram's evidence, Dubert is the case of versus Dow of 1993, which is relevant on the issue of evidence here. At the close of Weisgram's evidence, and again at the close of all the evidence, Marley unsuccessfully moved under Federal Rule of Civil Procedure 50A for judgment as a matter of law on the ground that plaintiffs had failed to meet their burden of proof on the issues of defect and causation. The jury returned a verdict for Weisgram. So that's a trial court. Marley again requested judgment as a matter of law, and additionally requested in the alternative a new trial pursuant to Rules 50 and 59 among arguments in support of its post-trial motions. Marley reasserted that expert testimony essential to prove Weisgram's case was unreliable and therefore inadmissible. The trial court denied the motions and entered judgment for Weisgram. Marley appealed. The Court of Appeals for the Eighth Circuit held that Marley's motion for adjustment or judgment as a matter of law should have been granted. Writing for the panel majority, Judge Bowman first examined the testimony of Weisgram's expert witness legally sound. The majority held the expert evidence incompetent to prove Weisgram's case. The court then considered the remaining evidence in light of most favorable to Weisgram, found it insufficient to support a jury verdict, and directed judgment as a matter of law for Marley. In a footnote, the majority rejected any its discretion to do so under Rule 50D, but stated, "We can discern no reason to give plaintiffs a second chance to make out a case of strict liability. This is not a closed case." The plaintiffs had a fair opportunity to prove their claim, and they fully admitted and that the appropriate remedy for improper admission of expert testimony is the award of a new trial, not judgment as a matter of law. So that was the plaintiffs' appeal to get them before SCOTUS. Courts of appeals have divided on the question of whether FRCP 50 permits an appellate court to direct an entry of judgment as a matter of law when it determines that evidence was erroneously admitted at trial and that the remaining properly admitted evidence is insufficient to constitute a submissible case. We granted cert to resolve the conflict, and we now affirm the Eighth Circuit's judgment. FRCP 50 governs motions of judgment as a matter of law in jury trials. It allows the trial court to remove cases or issues from the jury's consideration when the facts are sufficiently clear that the law requires a particular result. It gives a citation from Wright and Miller for that. Subdivision D controls when, as here, the verdict loser appeals from the trial court's denial of a motion for judgment as a matter of law. So I'm going to mark this because it's a rule that I don't think I got before. Let's find my markers. And that Rule 50 Part D reads, "The party who prevailed on that motion may, as appellee, assert grounds entitling the party to a new trial in the event the appellate court concludes that the trial court erred in denying a motion for judgment. If the appellate court reversed the judgment, nothing in this rule precludes it from determining that an appellee is entitled to a new trial or from directing the trial court to determine whether a new trial shall be granted. Under this rule, Weisgram urges when a court of appeals determines that a jury verdict cannot be sustained due to an error in the admission of evidence, the appellate court may not order an entry of judgment for the verdict loser, but must instead remand the case to the trial court for a new trial determination. Nothing in Rule 50 expressly addresses this question. In a series of pre-1967 decisions, the court refrained from deciding the question, while emphasizing the importance of giving the party deprived of a verdict the new opportunity to invoke the discretion of the trial judge to grant a new trial. Then in Neely, the court reviewed its prior jurisprudence and ruled definitively that if the motion for judgment as a matter of law is erroneously denied by the district court, the appellate court does have the power to order the entry of judgment for the moving party. Neely first addressed the compatibility of appellate jurisdiction of judgment as a matter of law, then styled judgment NOV with the Seventh Amendment's jury trial guarantee. It was settled. The court pointed out that the trial court pursuant to 50B, could enter judgment for the verdict loser without offense to the Seventh Amendment. Citing Montgomery Ward Company versus Duncan of 1940, as far as the Seventh Amendment's right to jury trial is concerned, the court reasoned there is no greater restriction on the province of the jury when an appellate court enters judgment NOV and when a trial court does. Accordingly, the court concluded there is no constitutional bar to an appellate court granting judgment NOV, citing Baltimore and Carolina Line versus Redmond, 1935. The court next turned to the statutory grant of appellate jurisdiction to the courts of appeals in 28 USC 2106, which it found certainly broad enough to include the power to direct entry of judgment NOV on appeal. The remainder of the Neely opinion effectively complements Rules 50C and 50D, providing guidance on the appropriate exercise of the appellate court's discretion when it reverses a trial court's denial of a defendant's Rule 50B motion for judgments as a matter of law. Neely represents no full face in the court's understanding of the respective competences at trial and appellate forums. Immediately after declaring that appellate courts have the power to order the entry of judgment for a verdict loser, the court cautioned. Part of the court's concern has been to protect the rights of the party whose jury verdict has been set aside on appeal and who may have valid grounds for a new trial, some or all of which should be passed upon by the district court rather than the Court of Appeals because of the trial judge's firsthand knowledge of witnesses' testimony and issues because of his feel for the overall case. These are very valid concerns to which the Court of Appeals should be constantly alert. Nevertheless, the court may continue due consideration of the rights of the verdict winner and the closeness of the trial court to the case does not justify an ironclad rule that the Court of Appeals should never order dismissal or judgment for the defendant when the plaintiff's verdict has been set aside on appeal. Such a rule, the court concluded, would not serve the purpose of Rule 50 to speed litigation and to avoid unnecessary retrials. Neely ultimately clarified that if a court of appeals determines that the district court erroneously denied a motion for judgment as a matter of law, the appellate court may, 1, under a new trial at the verdict winner's request or on its own motion, 2, remand the case for the trial court to decide whether the new trial or entry of judgment for the defendant is warranted, or 3, direct an entry of judgment as a matter of law for the defendant. I was surprised that we're talking about this then. The parties before us and Court of Appeals opinion diverge regarding Neely's scope. Weisgram, in line with some appellate decisions, posits a distinction between cases in which judgment as a matter of law is requested based on the plaintiff's failure to produce enough evidence to warrant a jury verdict, as in Neely, and cases in which the proof introduced becomes insufficient because the Court of Appeals determines that certain evidence should not have been admitted, as in the instant case. Insufficiency. Really is the question. Was it insufficiently argued by persuasion or insufficiently produced by a lack of admissible evidence? But that's my own words. Insufficiently, caused by deletion of evidence, Weisgram contends, requires an automatic remand to the district court for consideration whether a new trial is warranted. Weisgram relies on cases holding that, in fairness to a verdict winner who may have relied on erroneously admitted evidence, courts confronting questions of judgment as a matter of law should rule on the record as it went to the jury without exercising evidence inadmissible under Federal Rule of Evidence 702. These decisions are of questionable consistency with Rule 50A1, which states that in ruling on a judgment for a motion as a matter of law, the court is to inquire whether there is any legally sufficient evidentiary basis for the reasonable jury to find for the opponent of the motion. Inadmissible evidence contributes nothing to a legally sufficient evidentiary basis. As Neely recognized, appellate rulings on post-trial pleas for judgment as a matter of law call for the exercise of informed discretion and fairness to the parties is surely key to the exercise of that discretion. But fairness concerns would loom as large when the verdict winner in the appellate court's judgment failed to present sufficient evidence as when the appellate court declares inadmissible record evidence essential to the verdict winner's case. In both situations, the party whose verdict is set aside on appeal will have had notice before the close of evidence of the alleged evidentiary deficiency. See Federal Rule of Civil Procedure 50A2, motion for judgment as a matter of law shall specify the law and facts on which the moving party is entitled to the judgment. On appeal, both will have the opportunity to argue in support of the jury's verdict or alternatively for a new trial. If a judgment is instructed for the verdict loser, both will have a further chance to urge a new trial in a rehearing petition. Since Daubert, moreover, parties relying on expert evidence have had notice of the exacting standards of reliability such evidence must meet. It is implausible to suggest post-Daubert the parties will initially present less than their best expert evidence in the expectation of a second chance should their first try fail. And that's the main point. That's why I ran really quickly through the earlier points. Main point is that they don't have more evidence than what was shown, because if they did, they would have shown it when the 50A was raised. We therefore find unconvincing Weisgram's fears that allowing courts of appeals to direct an entry for judgment for defendants will punish plaintiffs who could have shored up their cases by other means had they known their expert testimony would be found inadmissible. In this case, for example, although Weisgram was on notice every step of the way that Marley was challenging his experts, he made no attempt to add or substitute other evidence. Exactly. That's the point. After holding Weisgram's expert testimony inadmissible, the Court of Appeals evaluated the evidence presented at trial, viewing it in light most favorable to Weisgram, and found the properly admitted evidence insufficient to support the verdict. Weisgram offered no specific grounds for a new trial to the Eighth Circuit. Even in the petition for rehearing, Weisgram argued only that the appellate court had misapplied state law, did not have the authority to direct judgment, and had failed to give adequate deference to the trial court's evidentiary rulings. The Eighth Circuit concluded that this was not a closed case. In these circumstances, the Eighth Circuit did not abuse its discretion by directing entry of judgment for Marley, instead of returning the case to the district court for further proceedings. Neely recognized that there are myriad situations in which a determination whether new trial is in order is best made by the trial judge. Neely held, however, that there are also cases in which a Court of Appeals may appropriately instruct the district court to enter judgment as a matter of law against the jury verdict winner. We adhere to Neely's holding and rationale, and today hold that the authority of the Courts of Appeals to direct the entry of judgment as a matter of law extends to cases on which, on excision of testimony erroneously admitted, there remains insufficient evidence to support the jury's verdict. For the reasons stated, the judgment of the Court of Appeals for the Eighth Circuit is affirmed.